All right, good morning, everyone. Thank you for joining this EUPLANT webinar. I see we're already with quite a few of us and some people are still trickling in. As we have a very interesting discussion and topic for today's lecture, I suggest we can already get started while some people are just still trickling in slowly. Good morning or good afternoon or good evening, depending where you are joining from. You're all very welcome. Now, today's EUPLANT lecture actually also serves as a guest lecture for our Chinese law course at the law faculty at the KU Leuven in Belgium. And the highly interesting topic for today's discussion is China, human rights, and the authoritarian international law thesis. The latter concept referring to the concept coined by Tom Ginsburg in his article with the same title dating from last year. Now, let me first maybe start off by providing you with some more details shortly about the EUPLANT project. EUPLANT is a Jean Monnet funded network that studies and teaches about legal and judicial cooperation between, on the one hand, China and the other hand, the European Union. And is actually comprised of a consortium of different universities, both here in Europe and in China. And here in Europe, for example, we have Queen Mary, King's College London, to which our speaker for today is affiliated, and the KU Leuven who are involved. And in China, there is, amongst others, also the City University of Hong Kong, who's involved, who our guest speaker of last week was affiliated, Professor Lin Feng. Now, before shortly explaining and going into today's topic, let me first provide you all with a little bit more background to our speaker. Already a very warm welcome to Professor Eva Pils. Eva Pils is a professor of law at King's College London and is also an affiliated scholar at the US Asia Law Institute of New York University Law School. And she's also a member of the Center for Human Rights Erlangen-Nuremberg. She studied law, philosophy, and sinology in Heidelberg, London, and Beijing, and obtained her doctorate from the University College London. Now at King's College London, Eva teaches courses on human rights, law and society in China, and authoritarianism, populism, and the law. And notably, she is also a member of the Academic Freedom and Internationalization Working Group and a Legal Action Committee member of the Global Legal Action Network. Her current research addresses autocratic conceptions and practices of governance, legal and political resistance, and forms of complicity with autocratic wrongs. And now Eva's specialization and research focus actually bring me easily to our topic for today's webinar, which you may already have read in the abstract of the invitation that was distributed. But just for introductory purposes, let me just shortly repeat the outline as provided by Professor Pils, so everyone has an idea of what to expect for today's lecture. Now, since its nominal recognition of human rights norms in the post-Mao era, the Chinese party state has relied in its efforts to maintain power on norms and practices of the suppression of specific human rights demands, the denial of civil rights, and the repression of human rights defense with reference to human rights with Chinese characteristics. It has portrayed criticism of China's human rights record as foreign attempts to infiltrate and destroy the Chinese system and campaigned for support for its position in international bodies such as the UN Human Rights Council. Now, in today's webinar, these developments will be discussed in the light of the arguments that the Chinese party state is playing a leading role in the creation of a new authoritarian international law. Now, Professor Pils has already provided us with a small preview into her viewpoint as well, namely by indicating that her analysis gives reasons for skepticism towards this much discussed thesis by Ginsburg. And now, before passing the word to Professor Pils, I will just briefly maybe discuss the structure of today's lecture. Now, Professor Pils will speak in total for about half of the time allotted to us, so for about an hour. And afterwards, we'll have ample time for Q&A. But Professor Pils wanted me to emphasize that she really wants this kind of to be more of a discussion-based lecture. So she has definitely indicated to very much pop any questions that arise during her talking points into the chat function, or we can also please do make use of the raising hand function, and I will be very happy to pass the word on to you so that you can interrupt and maybe ask some questions or some thoughts during Professor Pils's discussion. Now, I will also compile the questions also later on, of course, and we can also address those at that point. Now, lastly, just as usual, I think I'll repeat some housekeeping rules, as we're all accustomed to already. Just throughout the speaking points of Professor Pils, please maybe keep yourselves all on mute, so there are no unnecessary interferences. But of course, do raise some questions by raising your hand or using the chat function, as I've just mentioned. Now, if there are any technical issues in the meantime, please also use the chat function for that, and I will be happy to try to address those as swiftly as possible. Now, without further ado, I think I've already taken a bit too much of the speaking time, but a very warm welcome again, Professor Pils, and I give the floor to you. Thank you very much for joining us today.
Thank you so much. Thank you, Melanie. It's lovely to be here. It's lovely to be with everyone. And I look forward to discussing the authoritarian laws thesis with you. And thank you, Melanie, for emphasizing that indeed it is, I think, a good idea to do this in as discursive, conversational a way as possible. So I really welcome any thoughts, contributions, questions from you as I sort of work my way through the lecture that I have prepared, so that we make sure we stop and pause and address questions that you may have when they arise as far as possible. And so, Melanie, please do feel free to just let me know, because I will change into a shared screen function presently. Melanie, do please just let me know if there is a contribution in the chat or a raised hand that you feel we ought to be addressing straight away. And I, of course, also look forward to a sort of more open discussion section with you later. So I think that to move on to my presentation, I hope that that has worked and that you can all see.
Yes, we can see perfectly. Thank you.
You can see. Okay, excellent. So fundamentally, before going into a discussion of China, human rights, and the authoritarian law thesis, I thought that it might make sense to just very briefly remind ourselves of the importance of the date. It is, of course, about just over 100 years ago that in the May 4th movement, predominantly young Chinese challenged traditional Chinese values and authorities and demanded freedom of speech and democracy in the so-called May 4th movement, a very important date in the Chinese history that, of course, has also been claimed and one might say appropriated by the Chinese Communist Party, which having taken power in 1949, 70 years after the May 4th movement, as of course everyone knows, repressed another movement mainly driven by young people, students, young workers, some scholars, and so on. Another movement in defense of freedom of speech and democratic values was crushed and brutally repressed in 1989. And 100 years at the 100 years anniversary of the May 4th movement, President Xi Jinping celebrated this anniversary essentially by calling on all Chinese citizens, including its youth, including its students, to obey and follow the party. And that, I think, is a pretty good backdrop for another quick thing that I wanted to mention before going into a more systematic presentation of my topic, which is that only yesterday at a meeting in London, the current US Secretary of State, Antony Blinken, said that the US is not trying to contain China or hold it down, but rather what we are trying to do, and I quote, is to uphold the international rules-based order. And he argues that that is for the good or for the benefit of citizens around the world, including in China, and adds this reflection that when any country, China or otherwise, takes actions that challenge that rules-based order, we will stand up and defend the order. I thought that was, in a way, a good way of starting today's session, today's lecture, because what Blinken references here as the international rules-based order is very much what I think we need to discuss when considering how China's authoritarian system, its domestic system of governance, affects governance globally, and does so in terms of economic, discursive, coercive, and normative attempts to influence the global order. That is a question that, of course, we cannot really engage with without also asking ourselves how we should conceive of that global order. And you saw Antony Blinken, the seasoned diplomat from the United States, referring to what he called an international rules-based order, a rules-based international legal order. I think that that is an interesting concept, and I would like to invite you all, I would like to get us all to engage with and to some extent interrogate this particular phrase, and also engage with the debate about authoritarian international law proposed by Professor Tom Ginsburg, as Melanie has already mentioned. And I should, of course, also mention at this point, I think that she has a lot of expertise to contribute to this question. And I very much look forward, Melanie, to hearing your views as well a bit later on, I hope. So if we think about this broad question of how China's domestic governance affects global governance, then of course it makes sense very, very briefly to sort of recapitulate, to remind us of how law in China has devolved within China's domestic autocracy, in China's domestic system, which to specify the term used, for instance, in the Chinese constitution, is a people's democratic dictatorship. Well, what I would very briefly say is that while we saw in the post-Mao era, the era so often referenced as sort of the reform and opening era, 改革开放, an opening of the system that also meant the introduction of some limited bases for a legal order, and certainly recognition, at least nominally, of the idea, the rules and principles of human rights, marked by China's joining of several important human rights treaties. We have under Xi Jinping, that is to say, since late 2012, early 2013, unfortunately been witnessing a deteriorating human rights situation. We have, in particular, of course, we must remind ourselves, even though it is not specifically the topic of today's lecture, we are in a situation where there are increasingly compelling evidence of crimes against humanity being perpetrated in the Xinjiang Uyghur Autonomous Region, crimes that might perhaps even give rise to the equally, I would say, weighty charge of genocide, as I'm sure you're aware. There is a current debate about that. And thinking about how the system of governance has evolved under Xi Jinping, I would very briefly just state that I think we have, broadly speaking, seen a turn away from increasingly law-orientated and rule of law-orientated governance and efforts, at least at some nominal level, to recognize and incorporate human rights into the Chinese domestic legal system. We've seen a turn away from that and towards a system that now, under Xi Jinping, much more explicitly than previously emphasizes the importance of and the centrality of party leadership. And you could argue moves towards a more Carl Schmittian conception of law, a conception of law that is compatible with a market economy, but also perfectly able to essentially suspend law and legality when that is perceived to be convenient. And that basic mode of governance and that shift within the domestic system towards a deepening autocracy, a deepening form of authoritarianism, I think is quite relevant to the question of how China acts on the international level, where I think we can see China as an example of an expansion of autocratic influence. Sophie Richardson from Human Rights Watch has, in a recent piece, for instance, talked about development projects that can be characterized as rights-free. And of course, she's thinking mainly about human rights. Scholars have used phrases such as making the world a safer place for autocrats. And there have been, as I will spend a little bit of time discussing, overlapping economic, discursive, coercive, and normative strategies to expand China's influence. So very, very briefly, and this I think really should not, is not sort of my personal research focus. I would just say that there has been an expansion of economic influence that, of course, would make us think of instruments and mechanisms such as the Belt and Road Initiative, such as the Asian Infrastructure Investment Bank, trade agreements, and development projects affecting a wide range of sectors, including, and I think that's quite important, higher education. All of which are widely discussed in terms of various concerns, governance concerns, human rights concerns, security concerns, and so on, that they raise. And I think that at a discursive level, I would emphasize and highlight that China has also engaged in a kind of global outreach towards the media, the publishing industry, and certainly also into academia. So what does that mean? Well, we could look at an example used in a very widely discussed piece by Chris Walker. He mentions that, for instance, within the media industry, there are more and more commercial arrangements. His example is that of an ABC blockbuster deal with the Shanghai Media Group, commercial arrangements that on the one hand can give can give media companies in liberal democracies access to Chinese audiences, but on the other hand, can raise the problem of agreements essentially to self-censor. As Walker mentions here, the ABC management, obviously the ABC is the Australian broadcasting company, agreed to eliminate news and current affairs content objectionable to Beijing from its Mandarin language services in that arrangement. Another example more in the academic field is the famous example of Cambridge University Press agreeing to censor articles at China's request on the online platform that it was providing within China. Another example is an expansion of Chinese media companies globally into sort of beyond its borders. For instance, CGTN, the important Chinese party state television network operating abroad, uses the platform provided by the television network to broadcast problematic content. One example of that is the airing of forced confessions by Peter Humphrey, a British citizen detained in China on dubious charges and forced to confess to wrongdoing in settings that, as the illustration on the right-hand side, I think quite vividly makes clear, amounted to a forced confession. And there is the example, if we think about China's discursive global reach, of research collaboration programs where very often the Chinese party state or one of its agencies is the provider of funding for research projects that maybe in themselves have value and be attractive, but that can also be seen as tools, mechanisms, institutions to channel party state influence, project a particular message of the party state, or indeed also engage in censorship or self-censorship, pretty much along the lines of the example, the ABC example I just gave.
Eva, sorry
Yes?
to interrupt. I see that following on this point, I see that we have a question already in the chat box by Patricia Garcia Duran, and she inquires if whether you believe that the discursive outreach of China is to change human rights approach or to justify China, or both. So I think it's a broader question towards its intention or aims with that discursive power that it may have.
Oh, that's very, very interesting. Do you want to sort of briefly come and join us and sort of maybe expand a little bit on your question? So you juxtapose changing sorry, let me go to the chat.
Yes,
Patricia.
sorry. Yes, Patricia.
Hello. Hi.
Thank you very much. It's so interesting. This is why my question was about, okay, this seems to be China is making an effort to reach the Western society and to reach us. But I'm still wondering whether is a way of justifying their model, of saying that their model is all right within our norms, or whether they want to change the norm. That's my doubt. Thank you.
Thank you so much. Thank you very much, Patricia, if I may. I think that that's a really profound question. And in a way, I sort of feel that, well, for one thing, I feel curious about sort of what your take on the question is, but also I feel that this is really because it's sort of the a particularly profound question that perhaps we can kind of work our way towards an answer, which will have to address theories such as Tom Ginsburg's theory of authoritarian international law. But I think that your question, taking off directly from what I just said about these attempts, for instance, to influence Western media companies or indeed universities like ours in terms of what they do, it seems to me that you are suggesting that these activities in a way have more of a silencing character than, right? They try to stop us from doing certain things, perhaps highlighting certain human rights problems. Just potentially that might be one of the types of content that the Chinese party state might not want to see discussed on ABC or indeed within, within university campuses. But that silencing strategy doesn't really get us. I think that's what you're suggesting, Patricia. It doesn't really get us to the finding that China, the Chinese party state, is trying to somehow reshape the norms. They just don't want us to particularly talk about violations of human rights norms when that would be inconvenient to the reputation of the party state. Well, I mean, let me just briefly say, I agree with you so far as the analysis of this example goes. And so that requires us, and I'll try to do that, to, I think, sort of ask further questions about other forms of potential influence that the Chinese party state is taking. So let me see. Let me try and return. I hope I've now successfully done that to the shared screen and sort of ask about where else we see China's global reach in action. Oops. Am I sharing the screen? Yes. So I think that I would sort of want to highlight two further dimensions. One of them is what I call the coercive dimension, and that has so many different forms and shapes. But to give you a few that I think are important for us to keep in mind as we contemplate this authoritarian international law thesis. There is the pretty big topic of China, the Chinese party state, effecting fugitive repatriations, that is to say, the return of people that the Chinese government considers to be fugitives from its governance system back into China, using a variety of mechanisms, including the very formal mechanism of extradition that is essentially made on the basis of a host state decision, sometimes in accordance with extradition treaties. China also sometimes gets host countries to use their own laws, their domestic laws on deportation. There are some really fascinating US examples. But China also quite extensively, as we are learning, uses mechanisms such as sending security agents into host countries to persuade perceived fugitives to return. And of course, famously, as illustrated by the little picture on the left-hand side of Gui Minhai, it sometimes simply resorts to abduction of especially its own citizens back into China. And in the case of Gui Minhai, it is very important to note that he had acquired Swedish citizenship. There is also the use of what I would call cross-border users of domestic violence to control targets abroad. So to give you an example that I'm very familiar with, because I have spent a lot of my research career investigating the situation of human rights defenders in China domestically. Well, when these human rights defenders sometimes at the end of really horrible experiences of persecution, including enforced disappearance and torture quite routinely, if they eventually make a decision to leave the country to go into what is a sort of de facto exile, generally they find that even when abroad, the long arm of China's governance system can still reach them. They, of course, tend to be protected against measures of fugitive repatriation, accepting evidently abduction. They tend to be protected by the laws of their host countries. But even so, we find that human rights lawyers, academics, journalists, etc., who have left the country and live abroad are still being targeted by threats, sometimes without disclosing who exactly the threat is making the threat. They might be threatened with violence, get death threats, and so on. And also, unfortunately, the families of those who have fled China can be used, for instance, in cases of journalists whose relatives are locked up in order to control what the journalist is doing abroad. And then more recently, another use of the coercive power of the state, of course, have been sanctions that have been slapped on a number of researchers and indeed one think tank in Europe. I think many of you will be aware of the announcement only in March, only a few weeks ago, that certain scholars who had worked, among other things, on human rights violations and state crimes in Xinjiang, including Adrian Zenz and Joe Smith-Finley, as well as an entire think tank, also Björn Jarden in Sweden, I should say, as well as an entire think tank, the German Mercator Institute for Chinese Studies, was going to be affected by sanctions, including travel bans, but also a kind of prohibition on Chinese entities and individuals from interacting with them. And these sanctions in the EU sanctions context were even extended to associations and individuals who had been associated with the immediate targets. A way of using what is the kind of coercive power of the state that, of course, any country, any government has at its disposal in order to essentially control and influence what happens abroad, very often with a view to ensuring what is seen as law enforcement in the context of fugitive repatriations, and ensuring that the global image that that the Chinese government tries to convey is not undermined and disturbed and disrupted by critical voices abroad. And when I say that all countries have these users, these types of coercive power at their disposal, I should probably add two things. One, that for instance, the use of fugitive repatriations or indeed cross-border violence is sadly not limited to the Chinese party state. Think, for instance, of the murder of the Saudi journalist Khashoggi some years ago as a very troubling example of uses of cross-border violence. And secondly, that of course we need to distinguish between uses of coercive power that are in accordance with some kind of legal rule and those that are not. But this is where it gets difficult and tricky, because just the mere fact that legal rules are used in these contexts does not necessarily mean that these rules satisfy human rights requirements. Which brings us, I think, to a fourth dimension of China's global reach,
Eva,
which is, yes?
before going into the normative reach, I think we also have
Absolutely.
one more question going back to the economic influence.
Mhm.
I'm not sure if Leia, if I may, wants to pose the question herself through using the mic, or if she wants to let me go. Oh, go ahead. Yes. Hi.
Sure. Hello. It's very nice to meet you and to hear your insights. I'm personally doing a PhD on EU-China cooperation. So basically, it was a request for more elaboration on how do you think that the comprehensive agreement on investment and the AIIB are contributing, or how China is using them to promote this global reach, or how they are affecting global governance in some way. If you could elaborate a bit further.
Yes, I mean, I almost feel that we should probably throw this question back to you, Leia, and it's a very, very big question. But I think fundamentally, the issue, I think, with regard to all of China's sort of attempts to expand economic power is again one of governance. There is nothing inherently problematic. There's nothing wrong inherently with having trade relations as long as those trade relations do not either affect the governance systems of China's partners, or indeed make individual entities, associations, and sometimes entire foreign governments potentially complicit with specific violations, in particular violations of human rights that China is perpetrating. So I think that what I would say about the dimension, sort of the global economic reach, just to elaborate on these two aspects of governance. I think that one thing that we see in the area of economic of trade relations is that there is a tendency to move towards highly flexible and you might call it informal dispute resolution mechanisms that move away from the idea that transnational economic disputes or international economic disputes must be addressed and resolved on the basis of legal rules, and much more towards negotiated forms of dispute resolution. And the problem with that at the international, as much as the domestic level, of course, is that it does give rise to the concern that the economically or otherwise more powerful partner in the trade relation is going to be able to shape the dispute resolution in accordance with its wishes, so that essentially we end up with perhaps a resolution of a dispute that achieves settlement, but does not necessarily achieve justice. I think that there is concerns about the mere fact of investment creating dependencies and vulnerabilities in particular sectors of the economy, and so far as investment for instance, AIIB or other sort of entities and mechanisms facilitating investment promote that goal. There is, of course, concern that dependencies could give the Chinese government more influence. And in a way, I think that concern is one that really belongs to this broader concern of extending Chinese governance, not least because it is very difficult within the Chinese domestic economic system to find an economic actor that is independent from the party state. We all remember the discussion around Huawei, for example, that sort of very well exemplified, I think, the concern that control over an economic enterprise by the Chinese party state means that investment by that economic enterprise can create dependencies indirectly from the Chinese towards the Chinese government. And then I think in terms of the issue of complicity, I mean, I think that there we have currently, of course, a huge discussion about the CAI and the issue of whether that agreement should be ratified. And I think that at least part of the concerns that are being articulated there really relate to the fact that that trade relations with China can make trading partners complicit in, for instance, the importing of goods made with forced labor, and that in order to deal with that challenge, there should be much more explicit protections and rules preventing countries such as those of the European Union from effectively importing such goods on the grounds that doing so would make them complicit with the extremely severe human rights violation that is taking place within China. And of course, the example that is usually given is that of Xinjiang. I mean, I think that these are some examples of where China is not only exercising, sort of expanding its global economic reach, but where that expansion of an economic reach is problematic from a rule of law perspective. Does that make sense? Laia, what do you think?
Yes, it's very interesting how you put it, because I'm not a lawyer. I didn't study law, so this perspective is very, very interesting to incorporate it. Yes, I think it's especially what you said regarding the dispute settlement mechanism. I'm precisely now dealing with the fact that it's not included on the CAA and what that means, both for the EU, for China. How are they respectively trying to shape this reform that also Untitled is trying to promote of this area, and definitely China is known for its promotion of moderation, of agreement, of coming to an understanding and avoiding this legalization, and an independent jury deal with that. So why the EU is allowing this, it's also a very important question. So thank you very much for your perspective.
Not at all. And I think that that sort of that idea of informality, it sounds so attractive in many ways, right? It's quite a it sounds kind of nice, right? And of course, it reminds me, as a scholar very much focusing on China's domestic human rights, of the harmony discourse that we've had in China for a very long time. Harmony sounds great, but the problem, of course, of essentially proposing that dispute resolution should be consensual is that that consensus itself can be forced, and that what you call, Leia, the legalized mode of dispute resolution is often incorporates rules, procedural rules, and so on, that protect the weaker party in a dispute. So thank you very much for helping us to sort of work on that. And perhaps we can come back later or also on the question of, on sort of other questions raised by CAI and the issue in particular of complicity that I think is also really very interesting. And of course, I would be very interested to hear what Melanie sort of thinks about that. Do you want to come in right now, Melanie, or should we perhaps proceed?
I think it was also, I just want to note as well, I think it'd be interesting as well to see, for example, specifically AIIB, and mention on the economic dimension, economic influence that China has brought. I think there was a lot of discussion as well when the AIIB was first established, whether it really would be a China-influenced bank with social norms and standards and promoting that abroad. But I was also doing research on it as well of a couple years back now already, on really looking into the constituent documents of the AIIB and kind of comparing that with, of course, the World Bank, EBRD, and other MDBs. And actually that it was really, a lot of it is a copy-paste job that it was. There were certain innovative provisions in there, but if you also looked into where those innovative provisions came from, it wasn't really as much as an innovation really from the Chinese perspective, but they also got it from international sources. For example, the IMF for more, I think the G20 also raised certain aspects, and those were then taken into the constituent articles of agreement of the AIIB. And I think it's interesting to also kind of compare that and see that it's not always as much a black and white story, that they're always trying to exert their influence only for their own promotion of norms and standards, but it's also that they also want to take, of course, their global image, again, as you referred to already, Eva, about their global image, that they want to be a good or kind of a power that falls in line or doesn't do too many things that are too controversial on these aspects, but do want to be a good economic power on the international scene. So I thought that was also an interesting notes to add here.
Yeah, thank you very much. And I think that, I mean, that kind of reminds us that I think in many ways, China as an economic actor expanding globally is really working with the existing systems for international markets. And it isn't, in that sense, this also goes back to some extent to Patricia's rule. It seems to be in many ways quite fine with the existing, also the fundamental legal framework that facilitates, for instance, international trade and investment and so on. But I do think that if we look at the actors participating in international trade, international economic relationships, it is very important to remind ourselves that the domestic governance systems that structure these actors mean that just by virtue of participating in international economic relations, they kind of give huge direct or indirect influence to the Chinese government, to the Chinese party state. And that sort of nexus between the domestic system that sort of shapes who the Chinese economic actors on the international scene are, and international rules that govern trade, relations, investment, etc., etc. I think that nexus is also really important when we try to think about international economic influence. So I see that there are more questions coming, but I would actually quite like to, for the moment, press ahead a little bit, because I think I was just getting round to Patricia's question, which is there actually, does China, the Chinese party state, have a kind of normative global reach? That, I think, is the question that sort of animates comments such as that China and other autocracies are increasingly sort of dropping their status as norm takers or rule takers, and that they are becoming rule makers. And so We can look at different examples. I would just very briefly suggest that we look at two. One is the level of the United Nations. And so, for instance, if we look at the Human Rights Council, we can see that China has been quite an adept and powerful user of its mechanisms, including if we think of UN human rights mechanisms, the Universal Periodic Review process, where China has been successful in, as it were, countering a number of resolutions by liberal democracies, broadly speaking, in support of human rights, to condemn the ongoing state crimes in Xinjiang. Countering these resolutions, China has been able, for instance, to get other states, large numbers of other states, to sort of, as it were, make opposing resolutions that actually praise or at least endorse what China is doing in Xinjiang. And also China collaborates with and cooperates with other autocracies in resisting resolutions condemning human rights violations elsewhere in the world. There is, excuse me, also the promotion of the so-called win-win resolutions, resolutions by the UN Human Rights Council, that essentially, when you look at sort of the content of these resolutions, that again adopt very much a language of cooperation and harmonious interaction, in this case, mutually beneficial cooperation on addressing human rights issues. But that in making and using this language to essentially try to conceptualize how states that are member states of the United Nations should engage with international human rights problems, what these resolutions do is they really deflect the role of bottom-up critical transnational civil society organizations, and essentially say that addressing human rights issues is a problem and a challenge for governments who should come together and work together on these issues. And it is not a task for organizations such as these pesky international human rights organizations, that's of course my language, that criticize particular states over its human rights record. And it should also not be, the UN mechanisms should also not be used to challenge the domestic sovereign exercise of governance power by UN member states. So they reposition these resolutions, attempt to reposition international human rights law as solely a matter of state-to-state relations. And of course, if we think about China at the level of the UN, now I'd say two more things. One, I think that it is by no means clear that attempts like these win-win resolutions have been very successful in actually reshaping how the international community, how human rights organizations and sort of wider global transnational publics think about human rights and human rights mechanisms. They have also actually in some ways generated a lot of opposition as transnational civil society, including Human Rights Watch, the organization, of course, where Sophie Richardson works, have expressed their concern about the attempt to essentially move away from a conception of human rights law that sees transnational civil society as very much driving efforts to protect human rights internationally. And the other thing that I would say is that if we think about changes and threats to international human rights law, I think we should acknowledge that, of course, these challenges and threats have not arisen only from China or only from autocracies, but also from a number of countries under populist, democratically elected, but populist governments. And a very prominent example for that, of course, was the United States under President Trump. The second example that I would give, and we are discussing the Patricia's question right now. The second example that I would give of China's normative global reach is that of Hong Kong. Hong Kong, of course, is a special administrative region of China. It is under, it was reverted to Chinese sovereignty in 1997, but under rules partly protected by international law, in particular the Sino-British Joint Declaration, as well as the continued application of important human rights treaties, including the ICCPR. Rules that meant to secure a high degree of autonomy for China's legal system, and in particular also for the protection of human rights in China. Now, many observers have, and I think broadly speaking rightly, said that the introduction, or should I say imposition, of the national security law by the central authorities of China in Hong Kong in 2020 really very seriously undermined that legal framework I just tried to outline. The national security law introduces crimes of secession, subversion, terrorism, and also something called collusion with a foreign country or external elements to endanger national security. It very much weakens a number of institutional and procedural protections, including protections against being extradited into the mainland, effectively, I should say, extradited into the mainland criminal justice system, an issue that we just discussed very briefly when looking at coercive dimensions of China's global reach. And really importantly, it also, the national security law, and this is where we can see China's expanding normative global reach, the national security law kind of asserts global application in an article that clarifies that anyone, anywhere, anyone saying anything critical anywhere about the Chinese government, one may wonder, might be affected by the provisions of this legislation. And because the legislation particularly targets activities such as stoking hatred, quoting from memory of the government, I'm being quite serious in saying that if you take sort of the language of Article 37 of the National Security Law seriously, that would appear to mean that even criticizing, even critically discussing Chinese governance or Hong Kong governance anywhere in the world, as we are or I am currently doing, potentially seems to raise this specter that I might be in the process of violating the national security law of Hong Kong imposed in 2020 by the Chinese central authorities. And that, I think, is an example of an attempt essentially to produce legal norms that at least claim to have the authority and legitimacy of law, that also have a global reach, that reach into the world and seek to control what is done by a variety of actors well beyond China's national borders. The trajectory of Hong Kong has frequently been discussed as a kind of mainlandization of the special administrative region. And from my perspective, that is a development characterized by changes in the law, such as the national security law, as much as by practices like the cross-border abductions that I mentioned earlier on. I think I mentioned the example of Gui Minhai, but of course, there were some famous, infamous cross-border abductions also from Hong Kong. And that mainlandization, in turn, has sometimes been regarded as a process that that affects not only Hong Kong, but affects other countries, affects the world. And Hong Kong is sometimes sort of been seen as a kind of canary in the coal mine example of what is happening, of an expanding Chinese influence that affects us also abroad. So what to make of these examples of normative expansion? I will very shortly try and use a number of theories and concepts developed in the academic literature to assess these types of influencing that I have discussed. But I think that if we think about the example of the UN and these resolutions on the one hand, and of what happens in Hong Kong on the other, I guess that two things that we need to ask ourselves is what is the overall trajectory and purpose of the norms that China is trying to affect here? And then also, of course, we need to ask ourselves how effective is the attempt to reach out into the world by norms that are essentially articulated, shaped, enacted perhaps by the Chinese authorities. In that context, I would say remarkably, when you look at the kind of thrust of the win-win resolutions, as well as the Hong Kong national security law, I think that they have something in common, which is an attempt to disable dissenting voices and disable accountability through criticism and dissent. For instance, by shifting in the UN case, by very much emphasizing that human rights mechanisms are for governments to run and control, and human rights problems must be addressed in a collaborative manner by governments coming together to cooperate, rather than by criticizing each other, or indeed being challenged and criticized and perhaps taken to court by bottom-up civil society organizations. And in the Hong Kong case, rather similarly, the norms of the national security law very clearly, in my view, seek to disable dissent and bottom-up challenges to governance in Hong Kong, but of course also to China's broader human rights violations by intimidating and criminalizing the activities that traditionally, historically, Hong Kong civil society had relied on to sort of perform its role. So remarkably similar content there, a similar attack, I think, ultimately on civil and political liberties that have, of course, been very much part of international law. If we think about the effectiveness of attempts to change global norms, global governance norms, I'd say that there's a wide difference between the UN and the Hong Kong. There is a notable difference between the UN and Hong Kong examples. At the level of the UN, so far as I can see, I think that China has really only managed to disrupt mechanisms and procedures such as the UPR and to initiate the resolutions that I just mentioned, the win-win resolutions, but it hasn't really, so far as I can see, and I'd be very interested in your views, changed the content. It hasn't really changed the substance of major codifications of global governance, including international human rights treaties. And I think it would be very difficult to figure out how exactly these could be changed, but that is something for discussion. But by contrast, of course, because China obviously controls Hong Kong and controls it more and more as Hong Kong's constitutional system, unfortunately, is in the process of collapsing. In the example of Hong Kong, I think China has essentially introduced norms that are backed up by direct coercive force. And it has quite effectively, I think, ratcheted up the degree of transnational intimidation that it can use against critics or potential critics, not only in Hong Kong, but I think also beyond Hong Kong and China's borders, because at least at the level of intimidation, I think many people have taken note of the fact that the new law sort of claims this sort of global reach. I'm not sure if it would make sense to pause here briefly and ask if there are any questions or sort of comments on this. Let me stop the share screen and see. I see that there are lots of new questions, right, Melanie?
Yeah, some popped up just in the normative discussion, indeed.
Exactly.
I'm not sure if there are any you want to address first, or if I can maybe ask, for example, Elvin Miala, would you maybe want to bring your question, raise your question in the group? We could do it like that.
Yeah, hello.
Hi.
Not a problem
Hi.
at all. Hey, I'm currently an intern at the United Nations Human Rights Regional Representation for Europe. So it's super interesting for me here when you were talking about the European Union's actions, but also China within the United Nations. So my question was more specifically on what is actually, which advice and how would you advise actually those international organizations, the European Union, and more specifically OHCHR, to react towards those actions of China, and which efforts what they should do, how they should change maybe even their efforts?
Thank you so much. I think that's a really wonderful and incredibly important question. And I think that in a way, it's a good way of sort of segueing into what I wanted to talk about next, because I think that if we think about how we should respond or how the UN should respond, then we have to, from my perspective, start by trying to work out exactly how to conceptualize, how to understand the problem that we are looking at. And one of the issues that I think we have to think about is basically, and forgive me for slightly speaking off the top of my head, trying to think about whether these efforts by China to change the international legal order can be somehow justified or legitimized. If they can be, if we don't really have a good normative basis for being critical of what China and other autocracies are doing at international level, then in some ways, I'm afraid the answer to your question, Alvin, is that, you know, why that we don't have much justification for opposing these trends. And I think that it's that concern that has motivated me in trying to articulate some criticism of the authoritarian international law thesis. So what do I mean by that? Maybe I should very quickly go back into the presentation, but without forgetting your question, which I think we need to come back to a little bit later. So I think that there are various ways of thinking about China's expanding international influence. And I think one way, and I'm only going to mention it very briefly because it's so much discussed, is using this concept of sharp power developed by Walker, and whom I mentioned earlier on, and Ludwig, who basically says that in cases where, like the ABC example, the Australian Broadcasting Company example, where China essentially demands censorship from media companies like ABC, what it does is it exploits the asymmetry between liberal democratic and authoritarian systems. It uses essentially a new form of influence to insinuate itself within the sphere of democratic societies and then exercise control. And it does that in a way successfully just because our very openness, the very openness of liberal democracies, makes them kind of vulnerable. I think that there is something to that way of conceptualizing the issue, but I also think that in some ways, I have two concerns, and they go back to your question, Alvin. One is that I think that the conceptualization of Chinese influence of sharp power very much is interested in how China exercises power. It is much less focused on analyzing how that power exercise should be assessed normatively. I also think that when we consider how China exercises power globally, we have to, from my perspective, be careful with using a metaphor, the metaphor of the syringe or the dagger wielded by the authoritarian countries like China. We have to be careful with metaphors like that, because I think they very much suggest that the democracies are being merely victimized and that they are passive. But what Erwin reminds us of with her question is that, of course, the issue for us, for liberal democracies to consider is how they should react. And in other words, we must acknowledge that in these processes, we have agency. And we have responsibilities that we need to contemplate and that we need to fulfill under the international legal system that calls on us, for instance, among other things, to, as Antony Blinken said, stand up for an international rules-based order. So coming back to that question, I think that what we really need to ask ourselves is how to conceptualize that international order. And so I just mentioned very briefly, I went back to the initial quotation from US Secretary of State Antony Blinken, who said that the United States, of course he speaks for his country, must stand up to attempts to weaken the international rules-based order. And I think that that is a good opportunity, a good point at which perhaps we should engage with the idea of authoritarian international law introduced by Tom Ginsburg. And just to, before we very briefly listen to Tom Ginsburg, I think that I would like to just remind us of the question I just tried to articulate. I think that when thinking about responses, we have to be very, very careful with how we conceptualize the system that we want to defend. We will now hear from Tom Ginsburg, if the video transfer works, essentially suggesting that we might be witnessing a transformation of that system away from a liberal to a more authoritarian international law order. And if that is the case, then I think it raises with sort of great urgency the question of how we might address such a transformation. So let me briefly try and give the word, as it were, to Tom Ginsburg, if that works.
Joining us. And let me now turn to our panel.
Yeah, we can hear it.
Tom, let's start with a question. What is authoritarian international law? And how does it differ from international law as we have known it?
Great. Well, thank you so much, Mark. And let me, before I answer, just say what a pleasure it is to be here. The WJP and American Society are two organizations I've been involved with for a while and I care a lot about. So I'm really happy to be here. Authoritarian international law is a reflection of the moment we're in the world, which is we're now at a place where more countries are authoritarian than are democracies. More people live in those countries than live in democracies. And a greater share of global GDP is produced by authoritarians than is produced by democracies. It's really a profound shift. And my claim is that that is going to have some implications for international law. So whereas we usually, or used to think of authoritarians as using international law in a kind of Westphalian mode, pushing for non-interference and emphasizing sovereignty, mutual respect and such, that's not really feasible in the world we're in today. Countries are engaged with each other and just have to be by virtue of the frequency and intensity of cross-border cooperation. And so what we're observing is authoritarian countries now engaging with international law in a new way. And so I define it as international legal behavior and institutions that are designed to maintain and extend authoritarian rule across time and space. And it sort of reflects the fact that authoritarians tend to be very, very focused on the survival of their particular regime. It's a really diverse category. You know, the Saudi monarchy has little in common ideologically with the Chinese Communist Party or with Putin's Russia or Maduro's Venezuela. But we do know from the literature on war that authoritarians are not really prone to deep cooperation with each other. They fight and often go to war with each other. But in our moment, they do have a common interest in fighting back what is perceived as overreach of liberal democracies and a common threat that they face in liberal democracy. And I think the key moment in the current trend towards authoritarianism was really sort of in the early part of this century with the color revolutions in countries like Kyrgyzstan and Ukraine, Georgia, quite close to Putin's Russia. I think that scared Putin quite a bit. And whether or not there was Western influence on it, the people demanding democracy pose a major threat to an authoritarian regime. Obviously, the Arab Spring was another wave of threat, mostly fought off successfully by the authoritarian leaders. And so now I think what we're seeing is a sophistication into the use of international law. Now, in terms of, there's a common theme that we in comparative politics observe when it comes to authoritarian institutions. The average authoritarian country today is, doesn't look like Cuba or communist China. It looks in form perhaps like a democracy. It will have elections. It will have nominally independent courts. It will have a constitution with lots of rights and such. But what we are learning, and scholars invested in the study of authoritarianism are trying to understand, is that these institutions get repurposed by authoritarians to help them survive. So whereas an election in a democracy is designed to facilitate, turnover among different political parties, in an authoritarian regime, an election is designed to solicit information about potential issues that might be threatening, or maybe to co-opt particularly charismatic people. But it's not designed to actually allow for a turnover in power. And so it's in that spirit that I'm looking at international law, the idea that maybe these institutions that we focus on and we celebrate might, in the hands of authoritarians, actually allow them to extend their rule and secure themselves. So, well, what would that look like? I mean, I think in style, much of it looks like traditional Westphalian international law. That is, instead of seeing deep cooperation in international organizations, we'll see shallower cooperation. We'll see less emphasis on third-party dispute resolution, less emphasis on human rights, more emphasis on public exceptions, public purpose exceptions to human rights. And so that looks sort of like a return to traditional Westphalian thinking. But then again, what I'm trying to show is that we are also seeing really creative moves by authoritarians to develop structures that will help defend against potential threats to their survival. So I focus on 3 or 4, and a lot of the papers about regional organization, which I see as kind of a testing ground, a sort of laboratory for ideas that might then extend to the international sphere as a whole. So one example is the Shanghai Cooperation Organization.
Okay. So I hope that you found this interesting. I recognize that we have limited time, but I would very, very much recommend that you listen to the entire lecture by Ginsburg, who I think fundamentally sort of tries to grapple with the exact problems that we have just been discussing over the past 1.5 hours or so. And so what does he say? He basically argues that there is the possibility of a specifically authoritarian international law defined as rhetoric, practices, and rules emerging in the world. And so he sort of uses the example of the domestic undermining of an electoral democracy by a kind of typical contemporary authoritarian power holder to illustrate what he means. Namely, on the one hand, a kind of undermining and exploitation, if you like, of the international legal order based on conceptions of sovereignty, the Westphalian system, by authoritarian powers in the world who use that system, emphasizing non-interference principles, essentially in order to escape scrutiny or indeed challenge on the basis of international law. And of course, also systems that oppose, as discussed earlier on with Leah, international dispute resolution based on compelling and potentially coercive legal rules. And that additionally, and that I think is his main point, promote a normative development to facilitate cooperation across borders and discourage, I used the term disable earlier on, freedom of expression, association, etc., turning general international law more authoritarian. That, of course, is his big thesis. And the paper in which he discusses this, of course, very easily accessible online, actually puts a question mark behind authoritarian international law, and I think that is quite important. I'm now sharing a table from that paper just to illustrate how Ginsburg attempts to essentially come up with a typology of features, substantive and formal, that characterize users of and engagement with international law by democratic and authoritarian states as part of the international legal system. And so I think that this is a good moment to essentially pause a little bit, engage with Ginsburg's thesis, and also come back to Elvin's question: what does this analysis, what does any kind of analysis of the developments we have been discussing mean for how we should respond, how organizations like the UN should respond, or perhaps broader, I would say, how democratic transnational civil society should respond to these trends. So let's first sort of think about Ginsburg's analysis. The question, and the question, if we can agree with this idea that what is emerging is an authoritarian international legal order. Now, I mean, one thing that I would very much like to ask everyone, and I think we should come back to the discussion, is whether you think that the characterization of authoritarian and democratic systems that Ginsburg engages in here is adequate. So he basically says, for instance, democracies have rule of law, but autocracies have rule by law. And he also says that democracies emphasize civil and political rights like freedom of speech, whereas autocracies emphasize collective rights and essentially introduce all manner of what he calls exceptions for public purposes, limitations, I would suggest, of rights such as we briefly discussed when looking at China's domestic trajectory earlier on. And he says that democracies, well, very unsurprisingly, have a majoritarian decision-making process, whereas autocracies operate on the basis of unanimity. Is that a fair and helpful characterization? Can I sort of ask you, may I invite you to reflect on this and perhaps come up with some thoughts and comments? I think, Karin, you have your hand up.
Hello, Eva. Nice
Hi.
to meet you.
Great to meet you.
I had my hand up, but actually not to respond to this question, although maybe indirectly it is some sort of a response. I just wanted to say, I think this is really an interesting talk, and I basically agree on, most everything of what you say in your criticism of China. So the point I want to make is certainly not to disagree with you here, but I think that, and I see that you're trying to do this, and you've been doing this in your whole research career. So the point is, I think that if China would hear us now talking, they would consider your talk a sort of a subtle and well-informed variation of what they see in our media all the time, but then in a simplistic way. So I think their criticism would probably be that, of course, you can disagree with China, and I think also you can disagree with China, but what is really the problem is that we always take this high stance. You know, we have our norms and we are right. What's wrong with China? And certainly this criticism is legitimate, but if we always repeat the same in our media, it's just, I'm not going to say boring, but it's like one-sided. So I think what we would need is that more people, especially not so much talking about scholarship, because I think in the scholarly world it's fine, but among our politicians and among our journalists, people who know Chinese, who have lived in China, who can understand the speech, who can read the newspaper, and who can also add to this, you know, what we're discussing here, a variety of other voices, not just one voice that confirms the Chinese official position, but like a wide variety of voices. And I think that China is really irritated, and I think rightly so, by the lack of a variety of voices on our side. Like, can you imagine that Chinese journalists or political scientists would talk about America without being fluent in English? Without being able to, I'm not talking about you, and I'm not talking about the, you know, China scholars, but this is the case in Belgium. And therefore, you know, because basic people don't read Chinese and don't speak Chinese, they just have a pretty much always the same story in the newspapers, which is always confirming how much better we are than the Chinese. And I think without denying what you just said, because I also agree that, and it's not my field, but I do agree that it's worrisome what we see happening in the world. But I think we need a wider variety of views.
Well, thank you so much. I mean, if I may quickly get back on that, and I also can see that Patricia has her hand up. I think that in some ways, very briefly, I guess that your view is quite sympathetic to the broader project that Tom Ginsburg is pursuing by essentially introducing into our world of international law conceptions a theory that says there isn't only democratic international law. There's also authoritarian international law, and we have to engage with it. And doing that in a manner that I would say, you know, trying to be respectful and really understand Ginsburg, tries to get away from what you know, your view would probably see as overly moralizing conceptions of international law, such as are sometimes used by international human rights organizations. Now, you know where I stand on this, but I want to introduce a different perspective by bringing in Ginsburg's view into this discussion, because I think it is very important that we have this discussion, that we think critically about, you know, the very strong association between international law and democratic values that many of us would advocate. And so this is why I think we're having this discussion. On the issue of language, I mean, I have to say that as we're all, I mean, as we're speaking from Europe in a broader sense, I guess that we've all come to accept that we cannot know all of each other's languages, and still have to be able to sort of engage intelligently and sometimes also criticize each other. Although, of course, English is very widely spoken. Chinese does after all present a bit of a challenge to many, many people in the world. Patricia, did you have a view directly on the little discussion we've now started?
Yes, I have quite a lot of, I have had the pleasure to teach quite a lot of Chinese students, and they always are very surprised about our criticisms to their model, and they basically try to explain to me that the Chinese are not trying to impose their model into us, and therefore why don't we leave them alone? Mm-hmm. So basically we are the aggressor and the moralistic, and they are the good ones who just want the respect for the model, and they are not trying to change us, but we are trying to change them. Mm-hmm. And I always, my feeling, and I believe it's a little bit at the core of what we are saying here, is that to what extent human rights is a universal norm. Is what I mean is that it's not that we are trying to moralize, it's that we believe in our norms. Mm-hmm. So disengaging with China, for example, of course it has to be from the perspective of respect, but on the other hand, it also has to be from the perspective of our norms are universal. And this is, I believe, is the key thing here. We are not criticizing because we are not respectful, but because we don't believe that, or we believe that our norms are universal.
Excellent. Thank you so much. These are really wonderful contributions and very, very helpful in sort of setting, preparing the scene, I think, for what I was going to attempt to do in the following. And I will sort of go back to my shared screen just so that you have the benefit of that table and so on. But I will try to just get back to the views that you've just been sharing, Karine, Patricia, also Elvine's question, I think, very much plays into this, and get back directly. I think that you've very nicely confronted us with this challenge, that the challenging question of essentially how far the substance of current international law, which has been so much shaped by liberal democratic values, and I think we have to just sort of accept and face that, how far that substance is a kind of compelling intrinsic feature of having international law, and how far it may be open to, it may be subject to substantive change. That, of course, it is the question, it's Patricia's question of whether human rights are universal. And it's also the question of whether Tom Ginsburg's thesis works, namely the thesis that international law is not inherently liberal or democratic. It is not inherently shaped by human rights norms compatible with the political form of liberal democracy, but it can change substance, if you like. It can change color and turn to principles of authoritarian rule. So we could have this discussion entirely as a discussion about the universality of human rights. But I think that perhaps it makes sense very briefly, for me, very briefly, to tell you why I think that at a descriptive level, looking at this table, Ginsburg does not really fully account for the types of regimes that he's trying to juxtapose: democracy and autocracy, liberal democracy and authoritarianism. For one thing, I think that if we take seriously the idea of rule of law in democracies, we have to acknowledge that it depends not only on the substantive values of freedom of expression and so on, but actually encompasses all human rights, because from the perspective of liberal democratic theories of human rights, of the most persuasive theories of that kind, I think it is important to insist that human rights are indivisible as much as they are universal. And on the side of sort of his characterization of autocracy, I think Ginsburg sort of says that autocracies are systems of rule by law, looking at what he says here on this table. But then, are they? My experience as a scholar who has worked with human rights defenders in China for a pretty long time, and of course also beyond China, as a scholar who has interacted with lots and lots of different academics and journalists and lawyers and petitioners and so on, engaging with their own domestic system of governance, I would say that we cannot emphasize enough that governance, domestic governance in China relies not only on laws, on legal rules created to govern, but also on lawlessness, that it makes extensive use of the lack of accountability that characterizes authoritarian systems, essentially in order to control people using means such as human rights abuses that are not lawful, that have nothing to do with law, that in many cases, and we could think Xinjiang, we could think repression of human rights defenders, etc., actually violate China's domestic legal rules. And that is important, I think, because it gets us to a very important feature of authoritarian systems that are frequently ignored in the kinds of criticism that Karine very, very helpfully helped us articulate earlier on. These criticisms talk about liberal democracies, the US, the international community imposing rules on China. What I think these criticisms very often just choose to ignore is that the very rules and principles that current international law, in particular also international human rights law, supports, are actually rules and principles that many people in these autocratic systems, many people in China want. But of course, because they live in an autocracy, their voices can be quite effectively suppressed. And it's easy for autocratic regimes to suggest in global fora, especially for powerful autocratic regimes like China, that those norms represent an imposition precisely because they can disable and suppress dissent. So from my perspective, that makes it difficult to use when considering the role and sort of structure and significance of international law norms, to do that entirely sort of considering juxtaposing regime types and how different regimes' governments interact. And so I would that's sort of where I would be sort of inclined to be a little bit critical of Ginsburg's account of the trajectory that international law is going through. So he basically says that international law is sort of in a process of transformation, at least potentially from quite democratic to more autocratic. And a very important feature of that, a very important basis of the argument is that international law is nothing more than a rules-based order, rules the content of which can be changed. I think that that is an analysis that sort of, from my perspective, really fails to account for the inherent deep connection between fundamental rights and rule of law, but also sort of totally underplays the fact that when trying to expand influence, countries like China use law, they use treaties and the existing rules of international law and so on and so forth. They also use lawlessness quite a lot. And I've tried to give a couple of examples earlier on, citing, mentioning the way in which extra-legal and sometimes indeed even criminal violence is deployed transnationally in order to expand control. And I also think that there's something inherently a little bit problematic in the juxtaposition of these regime types. Now, I've sort of responded to your observations with a sort of a volley of sort of counter observations, if you like, or sort of further reflections. And I think that it would be important to loop back to the ongoing discussion. So I've just finished the share screen function, and so I'm not entirely sure I follow all of the contributions in the chat function, but what do you think? Are these criticisms of Ginsburg fair? Is he and what do you make of the fact that within autocratic societies there tends to be opposition, even though that opposition is repressed? Now, if that is the case, how can we talk of an imposition of values from the outside on these societies? Karin, you do have your hand up.
Sorry, I didn't realize that I had my hand up.
No worries.
But since you just, I just very briefly, I do not want to defend the Chinese view, and I don't want to be attributed with that one opposite view that is opposed to that other one opposite view. I was just criticizing the fact that there's too much of a one view here in the media, and that is to some extent related to a lack of knowledge and empathy with China. And I think it would be really good not only to talk with people in power there, but also with people who are dissidents, I think, who have a wide variety of views. It would really be good to know more about China. I'm not talking about you, of course. And so all the criticism you give that it's not even a law by a rule by law, because it's very often lawless. I mean, of course, I'm certainly not denying that.
No, I know, and I think that we share an interest and, if not even a passion for trying to essentially bring out voices that are too easily suppressed in societies like China. But I guess that the point, in a way, that then this raises is how the domestic suppression of dissent relates to what we should think about law at the international level. And I think that from my perspective, having worked for such a long time with human rights lawyers, human rights advocates domestically, it is very clear that no legal system can operate successfully if it disables the advocates that would try to use the rules of the legal system in order in ways that occasionally, of course, challenge the authorities. And that's fundamentally what human rights lawyers do. Now, if that's the case, I think we can transpose that to the international level and ask ourselves whether it is possible to have an international legal order that actually functions as international legal order when at the same time powerful actors within it, actors like China, are seeking to disable the voices of the advocates. At the international level, of course, that's the civil society organizations, that try to use UN mechanisms, etc. That's sort of domestic and international critics trying to hold countries like China to the standards of international law that it has signed up to. So Tom Ginsburg's thesis is that if we take away, we eliminate these, I mean, as I read Tom Ginsburg's thesis, he's trying to tell us that if we eliminate the human rights focus, the human rights content of the current international legal system, we weaken freedom of expression and association and related civil and political rights. We are left with a system that is still one of international law, that but that is no longer liberal democratic international law, but is authoritarian law. I think that is a deeply problematic thesis, because from my perspective, it sort of ignores the very, very important function that central human rights, including freedom of speech, have within the international legal order. And I think it is very difficult and problematic and risky to think of what autocracies like China are doing in their attempts to change, to expand international influence, as an attempt to create an alternative normative order. Patricia.
Sorry, can
Yes,
I can I briefly respond to this?
Oh.
But just, I'm not a specialist of international law, and I also don't know Tom Ginsburg, but just 2 points. I would say the fact that China accepts the notion of human rights, for example, I think in the Chinese view, that's only the beginning of the debate. It's not the end of a long debate where we end up agreeing. It's the beginning of the debate. They accept some rules, they accept some values, and then they start debating on what do you mean by them. I think they have always done this in their tradition. You agree on some values, and then you start debating on what it means. Well, secondly, you find this threatening and dangerous and you disagree with it. Me too. I mean, it's not because that's how they do it and how they want to convince us of what human rights mean that we have to agree and accept it. We can profoundly disagree. You do, I also do.
Well, I mean, I think that one of the, I have slight trouble with that characterization that China, I presume you mean the government, sort of accept the rules and then debate them, because in my perception, at least, you know, quite a lot of the activity of the Chinese government, especially at UN level, has been directed towards disabling debate, and in particular, disabling contributions from its domestic critics. Think Cao Shunfeng, who, you know, sadly died effectively in the attempt of to participate in a UN-based, Geneva-based human rights mechanism. And she's, of course, is only one of the human rights defenders who have suffered under that attempt to repress debates. And it's precisely that point that I've been trying to make. And I think it is a point that we can extend to a criticism of this idea that there is such a thing as authoritarian international law. I think law is inherently based on the exercise of fundamental rights. Certainly rule of law is. And I think it is that sort of, we have to sort of keep sight of that. We have to insist on thinking of the international legal order as an order that of international rule of law, not just a rules-based system. No, a rule of law at the international level. I think it is that we need to defend, and that should shape ways we think. And this gets back to Eveen's question. We should think of responding to the challenges that China and other autocracies pose to that order. I'm very sorry, because I think that we have 2 more hands up right now.
Okay, sorry, thank you.
Thank you.
I think Patricia, go ahead, yeah.
Yes, I'm sorry. A very quick question. Eva, do you believe that, is it possible to have, I believe what you are saying is that it's not possible to have a rules-based order without having a value-based order.
Mm-hmm.
And on the other hand, my question is, do the Chinese have a notion of human rights, their own one? Because I don't know whether they have a definition of human rights.
Okay, very quickly, I think first, yes, I agree. I would prefer the word principles. I think that there are principles inherent to the very idea of law that really call for substantive human rights. And you can use anyone from Ronald Dworkin to Tom Bingham to sort of essentially substantiate that conception of law. And it's a wonderful question. Thank you. And very briefly in answer to the second question, I would say no, because there isn't such a thing as the Chinese. There is a huge Chinese society with very, very different voices within it. But of course, the Chinese government, in much of its rhetoric, tries to suggest that there's such a thing as sort of a distinctly Chinese conception of human rights. That's where we hear about things like an emphasis on collective over individual rights, etc., etc. But I think that that's a deeply problematic characterization, because it just denies the naturally pluralistic conceptions of human rights that we find in Chinese society as much as in any other society. Thank you. There was one more.
Hello. In fact, I'm sorry for this name, U00. This is my but I happen to be a colleague of Karim. And just now in the chat, I added something, but apparently it was a little bit misinterpreted. So I just like to put this clear. I totally confirm what Karim is saying, that, you know, we have to open up the debate and see all perspectives. With my intervention, I only wanted to show the dynamics of what China is saying and how the United States are responding. So in the Anchorage talks, indeed, I think that was the first time that the Chinese came up so bluntly or openly challenging the legitimacy of Western international order. I mean, we've seen this coming all those years. I brought it out in an article on the strategic narratives under Xi Jinping and the Chinese International Journal of Politics. We've seen it coming, but I think in January this year, it was so clear that they said explicitly, why would Western actors have the legitimacy to stipulate the norms? And that's the only thing I wanted to say. I don't want to attribute certain views to Karim, but I think
thank you so much. And I think that, thank you so much, sorry to interrupt. But I think that's exactly the question that I also tried to articulate in response to Elvie. The question of, you know, sort of, is there, I mean, can we legitimately insist on an order, an international legal order that, historically speaking, has no doubt been shaped by, liberal democracies that we might call Western powers? My answer to that question is yes, because that order is inspired and animated by principles and values that are worth defending, and that are not by no means sort of intrinsically Western. I would also refer to the work of, for instance, Catherine Sekink for the historical part of that argument, very nicely showing that, for instance, in the drafting of UN documents, it was by no means only Western powers that sort of played a very, very important influence. Tom Ginsburg's answer to that question, I think, is much, much more reserved, because it suggests implicitly, if not explicitly, that authoritarian legality is a kind of plausible alternative, perhaps a defensible, perhaps a desirable alternative to democratic legality. And that is the argument that I've been trying to reject here. I know we're over time, but I also see that I think there was a person named Ishan who had something, a contribution. Oh, and Anastasia as well. What do you think, Melanie?
If you still have the time, Eva, for just a couple more questions.
2 more? Yeah, exactly. Yeah.
All right,
great.
perfect.
Ishan, yeah. And sorry for the pronunciation based on opinion. Ishan.
Hello.
Hello.
Do you hear me? Yeah, I agree totally with what you are discussing, and by accidentally I came to your lecture, and I find it very interesting and horizon broadening. What troubles me a lot is really to constantly hear this one dominant voice against the Chinese view of the human rights, for example, or the Chinese concept of development in the Western media. So I'm not against your points, but I just thought it might be more helpful to discuss with each other when we or when the Western scholars, Western students more openly view China as a actor in the international political things, but not as a enemy, for example.
Yeah, thank you so much. I'm so glad that you got to tell us this. Thank you very, very much. I think that is a big problem, and I think it's an increasing problem in an era where I think China is much, much more part of domestic political discussions in liberal democracies, no doubt. I mean, including all European countries, really. And where I think sometimes there is this perception being cultivated of China as a kind of homogeneous, huge, monolithic enemy of, countries or orders that are sometimes characterized as the free world. That isn't at all my view. Precisely because I think it is so important to appreciate the diversity of voices within China, as Karine also reminded us, as you just reminded us, and thank you very much. And on the other hand, I must say that I think that Chinese governance systems like the Chinese one, of course, like to kind of suggest that there is a Chinese viewpoint that is essentially determined by the Chinese Communist Party. Internally, domestically, they suppress diversity and pluralism. And so, of course, that kind of contributes to the problem, I think, because it suggests to us on the outside, who may be very casual observers of what happens in China, that the Chinese government speaks for China. And if that's sort of the impression we get, then of course it's easier for that to translate into a simplistic perception of China as monolithic, as having just one voice, and that voice being that of the Chinese government. So I fully agree with you that we mustn't give up on maintaining a more diversified discussion with different actors in China, elsewhere, and very much including individuals and organizations, scholars, journalists, anyone interested in promoting values and principles and ideas that may not be fully in line with those of their government. Thank you so much. Really, really great point. And then there was Anastasia.
Yes, thank you, Eva. I'm a PhD student on trade agreement and labor standards. Thank you for the very excellent analysis. Just a quick comment about the human rights notion in China and the definition. I think, China doesn't reject all the human rights as a package or accept as a package, but selectively, especially those rights, with access to health, to life, to clean water, etc. any individual rights are very welcome in China. On the contrary, those rights who can lead to people to associate and to have a collectively different voices, those rights are considered as, very threatening. For example, I don't agree with Ginsburg's analysis that collective rights are over individual rights. If you look at collective bargaining, freedom association in China, it's completely untrue. A second quick comment is, influence of China over the whole international human rights watchdog system, etc. I think maybe in the analysis so far, I don't see any financial aid analysis. How much China is allocating to influence human rights organizations, UN agencies, etc. In its overseas international aid package. Yeah.
Well, thank you so much. Really, two really great points. And thank you so much for actually answering one of the questions that I had put there on the slide. And of course, I totally agree with you. I think that it is deeply problematic for Ginsburg to sort of claim that autocracies kind of give preference to collective rights. But I would also say that the idea that China, perhaps like other autocracies, while not accepting the full package of human rights as we find it in international human rights treaties, does somehow accept part of the package, namely socioeconomic human rights, and that it actually sort of respects and promotes these rights. From my perspective, it's really problematic. I think that I've argued that, for instance, in a 2018 book on human rights in China, I think that when we look in very granular detail at what happens to socioeconomic rights in China, we can find that while the Chinese government has been good at promoting an overall increase in welfare, I don't think it has been at all good in promoting the protection, the defense of socioeconomic rights, especially in those cases where these rights have been violated by the government and where individuals seek to protect them through legal channels, etc. What we find in those cases, I think, is that because advocacy, human rights advocacy of any kind, tends to be repressed or at least disabled, what we find is that the lack of civil and political liberties inevitably has a disabling effect on socioeconomic rights. It stops it makes accountability for violations of these rights impossible. Think forced evictions, think labor rights, or environmental protection, and how much of advocacy in those areas can be suppressed in China. And I think that's important. It's important, obviously, as a potential criticism of what the Chinese government is doing, but I think it's also important as a criticism of a theoretical account like Ginsburg's that seems to suggest that you can divide human rights. And here I would go back to a point I tried to make earlier, which is that I think that human rights as an idea is really not divisible. This, of course, is also unsurprisingly the position taken by the UN. Human rights are interdependent, and it's not possible to only take part of the package. But it's, of course, that very problem that leads to the kind of inherent tensions between the idea of human rights as protected in international law and the practices of autocratic governance. So it's a really profound question that perhaps to some extent also goes back to the question raised by Elvin earlier on. And I can see that we could sort of continue discussing this topic. I can see that there's interest, for instance, in analyses of media freedom. And I think that in that context, it's certainly, as in many other contexts, it's certainly important to recognize that, of course, it is not only in China that we find disturbing systematic human rights violations. That incidentally, was a third point of criticism that I would want to make of, cautiously want to make of Ginsburg's thesis. I think that it very much relies on this idea that we have different regime types in the world. And while I have been using the concepts of autocracy and democracy throughout the discussion this morning, I think that we also need to recognize that some practices used by autocracies are increasingly perhaps also used by democratic governments, and that in an age of that some have characterized as democratic retrogression, an age of weakening democracy being undermined domestically, including in several European countries. I think we need to be careful with that sort of juxtaposition of regime types.
Can I just pick up on this point, Eva, as well? I fully agree as well that we have to be careful with that juxtaposition, indeed, because there are a lot of different types of democracies and a lot of different types of autocracies as well. So going back to the table that you referred to from Professor Ginsburg's article as well, I think it's, or it might be difficult as well, indeed, to put some characteristics under democracy or autocracy that work for all of them. And that's something just that we have to be careful about. But I was also wondering as well, I had a question picking up on this, if you would find it also interesting to maybe then also see in that table, for example, he set out pro-democratic and liberal international law across from authoritarian international law. Do you think it could also be of interest to maybe, of course, keeping in mind that it's also difficult to put characteristics under different concepts, but maybe also make another category and look at how illiberal international law is playing a role there, separate from authoritarian international law. Of course, there will be a lot of overlap, but it might be interesting to also get that really into perspective, the different practices under those two.
Yeah, thank you so much. I mean, I think that, of course, conceptually separating out authoritarianism and illiberalism is a really useful, useful and helpful idea. And Marlies Glasius, for instance, does that in a really wonderful way in her paper on, I think from memory, in her paper titled "What Authoritarianism Is and What It Is Not." And she points out that sort of disabling voice and disabling accountability are different, sort of different practices, different types of practice. I think that from my perspective, and in answer to your question, I would say, because I have a problem with the idea that there is such a thing as authoritarian international law, of course I also have a problem with the idea that there's such a thing as illiberal international law. But I think that your suggestion is really brilliant and really important, because I think that the rise of illiberalism is something that we can observe across systems that we might currently want to classify as and characterize as liberal democracies. The United States, which we've been mentioning for obvious reasons a number of times, is an example for that. But so are many European countries, where the rise of populism has led to numerous practices, attacks on the media, as much as attacks on, for instance, independent judiciaries and so on, the whole idea of fake news, etc., being deployed, I think, as tools to undermine the values of a liberal democracy that are meant to be protected through international human rights law, through the international rule of law. And I think that we have to engage with that phenomenon. From my perspective, of course, what we're looking at isn't so much the rise of an authoritarian or an illiberal international legal order as the undermining of international rule of law. And I think that what I would suggest is that what we see in these contexts is a kind of rise of practices of lawlessness, of the, as Frankl would have put it, the prerogative state undermining a rule of law, but of course in our era, not just at a domestic level, but also at the level of the international community and international law. So thank you very much for that question. That was very much sort of a point that I was hoping to make.
Okay, I think we've taken up maybe too much of your time already, Eva.
My pleasure.
Thank you very much for having this lecture with us. I would like to thank the audience as well for joining, the participants for their very interesting questions that we were able to make this a debate. And again, thank you very much, Eva, for the very interesting lecture. I think everyone enjoyed it very much and has given us a lot of thought for the future as well. So thank you very much for joining us, and hopefully next year, maybe again in person.
That would be wonderful. Thank you. Thanks very much.
Yeah.